Mr. Gregoza and Ms. Turner, it appears you are both in the virtual courtroom. So good morning, Mr. Gregoza, you may proceed.
Thank you, Judge. Good morning. My name is Steve Gregoza. I am the Special Assistant Public Defender for Mr. Valenzuela. I'd like to reserve 5 minutes.
Very good.
The issue in this appeal is whether or not the court erred in denying the duress instruction that Mr. Valenzuela had requested. Now, basically, this case involves Mr. Valenzuela, who lived in California. He was having financial problems. He met with a former friend of his wife, a guy by the name of Victor, who told Mr. Valenzuela, and this is all that Mr. Valenzuela testified at trial, that Victor could help him out and give about $9,000 if Mr. Valenzuela would drive some money across the country from California to various parts of the United States. and Mr. Valenzuela agreed. Subsequent to that, Mr. Valenzuela received a phone call from somebody in Mexico, spoke to him in Spanish, and basically said to Mr. Valenzuela that you have a very lovely wife. We can take care of her. He knew his wife's name, Liz, her nickname, and he told him that you're gonna meet up with Victor and just do what Victor tells you what to do. Now, Mr. Valenzuela testified that this really unnerved him because all of a sudden this guy in Mexico knows his wife's name, his nickname, and knows a little bit more about him, and he was surprised. And he's also being a Mexican, or I guess a Mexican-American, he's also aware of the tentacles that the Mexican cartel has into the Mexican people in California, so this really scared him and unnerved him. He didn't know what to do and he wanted to get out, but he didn't do anything. And a couple of days later, Victor came to Mr. Valenzuela's house and said, okay, let's go. And without any notice, so let's go. They rented a car. And with the rental car, Mr. Valenzuela drove the car to a house based on where Victor was telling him. And at that point, when they were at the house, they drove in a garage. Mr. Valenzuela saw that the car was being loaded with drugs. So this was the first time that Mr. Valenzuela knew it was a drug deal. The car was loaded with the drugs, and Victor told Mr. Valenzuela, okay, you're going to drive across the country, go to Florida. Do not take Route I-10, take Route 20, and do not go through any southern states. Every time you cross the border, you call us. Every time you stay at a hotel, you call us. When you leave, you call us, and we'll stay in touch that way. So Mr. Valenzuela drove across the country to Florida, and when he arrived in Florida, Victor told him, you're going to meet an individual by the name of Javier. And follow whatever.
I want to make certain I understand, as he drove across the country, he was by himself, correct?
He was all by himself. That's correct, Judge. And when he arrived in Florida, he did meet this guy, Javier, and Javier said, okay, Victor said he obviously knew it. And they drove to a house in Polk County. The garage door opened, they drove inside the garage, the drugs were being taken out of the car, and it was a setup. The police came and arrested Mr. Valenzuela. At trial, Mr. Valenzuela presented the same evidence and asked for the duress instruction. However, the state had put on evidence that showed that after Mr. Valenzuela had been arrested and gave a statement, Mr. Valenzuela never said anything about being fearful, never said anything about being set up by the Mexican cartel, never gave any information about that at all. So when the defense asked for the jury instruction, the court ruled, well, how do you basically put that together with Mr. Valenzuela saying nothing about the being fearful in his recorded interview with the sheriff's office? And the defense argument was, well, all that is a question of fact for the jury. And the case law does say that when the court is determining whether or not to give the duress instruction, the court has to consider the factors in best light for the defendant. Just as a JOA has to be considered with the facts best light to the state, here the facts of whether or not a duress instruction should be given have to be considered in the best light for Mr. Valenzuela.
Well, doesn't the trial court have to determine if those factors have been sufficiently demonstrated?
Well, I think I agree with you, Judge, but I think
because my question is, it only appears that any type of alleged threat occurred over the phone when a phone call that occurred 2 to 3 days before he even picked up the car. And Mr. Valenzuela conceded on cross-examination that his wife is Facebook friends with the caller. And he said, I'll take care of her. He didn't say I'll kill her, I'll harm her, or anything else. I'll take care of her. And then Mr. Valenzuela testified or said to the police that he did this to make $9,000. So to just move one car from across the country to another state on the other side of the country for $9,000 and not to think that it may involve drugs is a little bit incredible.
Well, I have two responses for that, Judge. First of all, I don't think the record shows that the caller from Mexico was on Facebook with his wife. I think Mr. Valenzuela didn't know who the caller was, okay, but maybe I'm wrong, but I don't believe that's what the record showed. But and I agree. It may sound
Victor was correct.
Victor was, that's correct.
Yeah,
But not the caller from Mexico.
but the
who
caller
gave you-
obviously knew Victor.
That's correct. So I think that the question comes down to is, when you look at the factors in favor of the defense for duress, does that become a jury question? And I would suggest that when you have an implied threat, and I think that's for the jury to decide, even though there was no direct threat, we're going to kill you if you don't do this. And at that point in time, okay, Mr. Valenzuela said he believed it was going to be dealing with money. But the point still comes down to, is that a jury question? And I suggest that when you look at the factors to determine, whether or not the threat was real, imminent, and impending, that's for the jury to decide, not for the court to decide.
Well, you have to make a threshold showing that the threatened harm must have been real, imminent, and impending. So what evidence was there to make that threshold showing that the threat was imminent or impending?
Well, the only evidence we have of the threat was a phone call from Mexico, from the man in Mexico. But what that man said, that he knew Valenzuela's his phone number, his home phone number. He knew his wife's nickname, and he said, "We'll take care of it. You have a very lovely wife." He took
Okay,
that
so
as a threat.
let's give you the benefit of the doubt and say,
Mhm.
okay, that could be construed as a threat. So let's take that as a given that that's a sufficient threat. Where is the evidence of it being imminent or impending?
Well, I think that I think becomes a jury question, a question of
Well,
fact.
but you still got to make a threshold showing.
I agree, and I think that it's imminent and impending. The fact that, first of all, he's no longer under the control. He can't control this himself. He's under the control of Victor. And
He's not under anybody's control. He's sitting in his house on the phone.
No. I'm talking about when, right, at that point in time, the question is, was there a threat and what did he do? But what I'm saying is, subsequent to that, Mr. Valenzuela, when Victor came over, when Victor came back after the phone call from the man from Mexico.
A couple days later, correct?
Well, the testimony
next
was
day at
either the
least.
next day or a couple days later, right, between 1 and 3 days, let's say. And at this point in time, according to Mr. Valenzuela, he wanted to get out of it, but didn't know what to do and didn't know how to do it. So I suggest that the issue now becomes, was that a threat? Was it impending? Was it real? Was it imminent? But once Mr. Valenzuela got under control of Victor, for example, he gets the car and he's driving to Florida. They know where he is. He has to call in every time he crosses a state line, every time he gets gas, every time he goes to sleep, every time he wakes up. They know where he's at. He goes to Florida. The Javier gets in control of him. So from the entire time that Victor showed up, and don't forget, Victor showed up out of the blue after the phone call with no notice to Valenzuela other than, let's go get the rental car. So
Well, is it undisputed that your client was going to get paid for moving this car no matter what was in it?
No, I don't, that's not in the record, Judge. All I can say is.
Or are you arguing he did it for free?
No, I'm not saying that.
Okay,
I'm
then.
saying-
So if I'm paying you to move a car, I would like to know where you are to make sure that you do what you're supposed to do, whether it's drugs or just a legitimate transaction. So how is keeping track of him a threat when there is no threat other than I want to know where you are?
Okay, well, I would suggest that when you look at the amount of drugs that he had in the car, that's a big difference of an illegal activity than it is transporting some money across the country. So I suggest when you consider the factors of what we all know about the Mexican cartel, and he's dealing with a large amount of drugs that have been hidden in his car, and he knows it. So he's not dealing with people who are just going to, if he loses the money, say no big deal. These are professional players in this thing.
But had he had any prior dealings with them to where he could testify about any prior acts of violence or any propensity for violence that could have been admissible? Because that would be
No.
admissible to show duress as a prior propensity for violence, but I didn't hear any testimony that he knew these people were violent.
Well, I
He
think
dealt
it could,
with them.
well, I agree. But I think that's a question of fact for the jury. When you see the amount of drugs, this is not where he had a couple of pounds of marijuana. He had a huge amount of narcotics in his car that show that this is not just some person selling something. This is really on a commercial level that would involve the Mexican cartel or even from Colombia or somewhere. So I think just that in itself would show we're dealing with people who have the propensity for violence. It's well known.
Mr. Barboza, when he was first arrested, did he tell the police that he felt terrible, he was pressured into doing this, he was under duress?
No, he did not, Judge.
So when is the first time that he asserted any duress causing his actions?
Well, the only thing I have is the record, so I don't know. And I did talk to him in prison, and he didn't really want
If
to
it's not in the record, it's not in the record. But in terms of what the record reflects, it appears the first time there was a claim of duress was at trial.
That's what I can find from in the record, that's what we have, right? The first time he did it according to the record was at trial.
And so he drives cross country. There's no indication that he felt he was under duress, that he had to go across country. And I understand what you're saying from the factual background, but he's arrested. He actually gives a recorded statement to the police, doesn't say anything about he had been threatened to do this, correct?
That's correct.
And is that an appropriate factor for the trial court to consider in determining whether or not a duress instruction should be given?
Well, I think it is, because I think there's only a minor threshold that he has to present. Then it goes to a question of fact to the jury. I would look at it. I suggest to the court, let's look at it in reverse. Was there enough for a jury to determine a question of fact? I think if the court says, yeah, there was enough, a question of fact for them to make a determination as to whether there's duress, then I think the court can say, well, if there was enough for a jury to say that as a question of fact, and that's when the court has to look at all the factors in the favor of the defendant, then the question comes down, well, if it's sufficient there, what should have been sufficient to show that to the judge? I mean, I suggest when you're looking at these factors, for the judge just to say, well, I just don't believe it, it's not enough, and to take it out of the jury's hands.
Let me ask the question this way. Is it your position that under factual circumstances such as this, no matter how much time goes by from what is perceived to be the threat until the defendant asserts that he acted under duress, you're saying as long as the defendant comes up with a claim of duress and there might be some evidence to support it, that the trial court is abusing his or her discretion in not giving the instruction? Is that the position you're taking?
Yes, it is, Judge.
Okay.
I think if there's a factual basis, whether you look at the factors in favor of the defense, just like a JOA in favor of the state, then I think when you look at what happened at trial, the factors that were presented to the jury, I suggest were sufficient for the jury to make a determination, was it duress or not?
I think you've got a real uphill battle with that. I mean, I have a hard time seeing how you even get past Stevens. And if the court concluded that the instruction wasn't warranted in Stevens, and I don't, if you don't recall that case offhand, that's the one where there were definite threats to do harm to threaten to torture and kill the defendant's mother and girlfriend. The next day he found the severed cat's head.
Oh yeah, I remember that one. Right.
Yeah, that everyone remembers the cat head. How do you get past that case when there was no error in not giving the instruction?
Well, I think the court has to look at how the judge ruled. The judge didn't make any specific findings as to those other cases or say, here's this or here's that. The court said, the court's determination was, your client never said anything to the sheriff's office after he's arrested about the threat. That was the court's basis to make that ruling. That was it.
And maybe the court got the reasoning wrong, but still reached the right decision. We can consider that, can't we?
Well, yeah, but I think that always gives me a problem. We got when you try to use this tipsy coachman doctrine, but the point still comes down to, let's say you got the reasoning wrong. If you got the reasoning wrong, then shouldn't the jury have been able to decide that then? I would suggest it is.
Let me just let you know you have reached the 15 minutes of your argument. So if you wish to reserve your 5, now is the time.
Yeah, I'd like to reserve 5, Judge.
Very good. Thank you very much. Ms. Turner?
Thank you. May it please the court, Lindsay Turner on behalf of the state of Florida. So a defendant is entitled to an instruction on the law applicable to the asserted theory of defense if there's any evidence to support it. And it is true that this is a sufficiency inquiry that the court should engage in, not a weighing of the evidence at that juncture. But I have 2 points to make as to any argument that the trial court inappropriately weighed the evidence. And the first is that the record does not clearly show an improper weighing of the evidence by the trial court here. If the court would reference page 227 of the trial transcript, there's kind of a fragmented collection of statements that doesn't equate to a complete ruling for one reason or another. But importantly, there's no request by the defense to clarify the court's ruling. There's no motion for new trial filed after the fact to explore the standard used by the court. But regardless, under the tipsy coachman doctrine, as the court mentioned, this court has to affirm if there's any evidence to support the ruling, even if it was right for the wrong reason. And so the evidence required for a duress instruction are those 6 elements laid out in the standard case and mirrored in standard instruction 3.6K. And here there was simply no evidence presented by the defense to demonstrate elements 3 and 4 of the duress defense, which require the real, imminent, and impending threat of harm from which there's no reasonable opportunity to escape without committing the crime. And we know from the case law that an imminent and impending harm is one that is continuous, about to occur. It's something that can't be guarded against by calling for law enforcement's assistance. And as to the Stevens case, that's the same argument that's being advanced, that if there's any evidence, regardless of how meritless it may be, makes it a jury question. That was argued in the Stevens case and rejected. The court then went on to consider the sufficiency of the evidence and found, as was noted, that the evidence was legally insufficient for a duress instruction. And so what we know underlying all of the cases cited in my brief is that a vague threat of some possibility of future harm is legally insufficient for a duress instruction. And viewing the evidence here in the light most favorable to the defense, that's precisely what we have here, even if the call was to be construed as a threat, which, assuming to the defendant's benefit that it was, this was precisely the vague threat of some possibility of future harm that has consistently
You know what's interesting, Ms. Turner, is the very first thing you said in opening your argument is if there is any evidence of duress, then the instruction is supposed to be given. Well, there is some evidence of duress, right? His testimony.
Well, there is some evidence to support a number of maybe some of the elements of the duress defense, but I would submit that there's no evidence to establish the imminent and impending threat of harm, because when we view the evidence here in the light most favorable to the defendant, he had several reasonable opportunities to do a number of things short of committing the crime in this case. He testified that 2 to 3 days passed between receiving this phone call with the alleged threat and then picking up the rental car in California. And then, as has been noted, he drove across the country by himself over a period of 3 days, over 3 days. And during that time, he stopped at a number of places along the way, including truck stops and hotels and presumably gas stations to refuel. And then one thing that was left out is once he was at the rental house where the buy bust occurred, they realized that there was no, they didn't have the correct tools to open the door panels. So the defendant went by himself to a Home Depot to purchase the correct tool, and then came back before being arrested and helped to remove the drugs from the car. So in the light most favorable to the defense, he had several reasonable opportunities to contact the police or to warn his family and have them removed to safety. And for those reasons, the state would submit that it's the evidence was legally insufficient for a duress instruction. But even if the court were to conclude,
is your position, my understanding that your position is that there was insufficient evidence of duress, which is essentially no evidence of duress, or there was some evidence of duress?
my position is that there was no evidence of duress because he did not present any evidence to establish some of those elements of the duress instruction. But even if we were to conclude that there was sufficient evidence and that the trial court abused its discretion in instructing the jury, it was harmless beyond a reasonable doubt, because we have that statement post Miranda where the defendant admitted to committing this crime because he was severely in debt and he was going to receive $9,000 for making this cross-country trafficking trip.
Ms. Turner, was this Mr. Valenzuela's sole defense, duress?
No,
It appears that it was.
Well, there was some argument, I believe, that he didn't know the illegal nature of the narcotics, I believe was asserted at some point. But he did argue in closing some of these elements to assert the duress.
Well,
defense.
help me out, because it seems the threshold for a defendant to get the instruction is pretty low. And he must demonstrate, he doesn't have to prove it. But help me out and help me reconcile the fact that the trial court, the case law is clear, the trial court cannot weigh it, but yet we're sitting here saying that it was sufficient. I mean, counsel's saying it was sufficient, you're saying it wasn't sufficient. So how do you get to sufficiency without weighing it?
Well, I would submit that the sufficiency as to those two elements that I'm maintaining were insufficiently proven. That is looking at the evidence in the light most favorable to the defense and determining whether there was evidence to establish as a matter of law, was this a real imminent impending threat of harm? And there was not. When we view the case law cited in my brief in the Stevens case and the Carujo case from this court, this was legally insufficient to establish a duress instruction. But as to the weighing, this court can then weigh it in a sense in the harmless error analysis, because we have his statement and it's corroborated by the other testimony from the detectives regarding his calm demeanor as he went through this, and his substantial participation in removing the drugs from the car. And the fact that has been noted that he never mentioned this threat prior to his trial testimony, all of that demonstrates beyond a reasonable doubt that he committed this crime for economic gain and not out of duress. And for that reason, the lack of a duress instruction was harmless beyond a reasonable doubt.
Let me ask you this. In my mind, were there any more threats, implied or direct, after the phone call?
No, there's no evidence of that at all. And the defendant even testified that Victor and Javier never threatened him. And then during the Miranda statement that was recorded, the Detective Van Camp, went through his phone with him and viewed the text message threads between the defendant and Victor and Javier and confirmed that there was no threatening nature reflected in those text message streams. So yes, the only evidence was the phone call in the record. So if there are no further questions that I can answer for the panel, the state would rely on its brief for any remaining issues and ask the court to affirm.
Very good. Thank you very much, Mr. Turner. Mr. Gregoza, you have 5 minutes for rebuttal.
All right, thank you, Judge. You know, the rule is that if there is any evidence, let me read it from standard what it says. A defendant is entitled to have the jury instruction on the theory of defense if there's any evidence to support it. So the question the court has to determine, was there any evidence to support this duress instruction presented at trial? And I suggest there is. I mean, even if you just look at the implications of what we know of a Mexican cartel in a large quantity, we're not dealing with people who will just play around. This is some serious business here. And I think the implication for a jury to understand is that, people do die from this. It's not like this is not known that this is what happens. And it's, as I said before, if we're dealing with a small amount of marijuana, a small amount of drugs, that's one thing. But we're dealing with hundreds of thousands of dollars worth of narcotics here. The only people who can put that together are some real serious professional killers who deal with drugs and they know what they have to do to get it done. And I think that is something that shows, just that fact itself is an indication that with this man calling Mr. Valenzuela from Mexico and giving that information, there's an implied threat there. He really didn't come out and say, we're going to kill you, don't do this. What else would they do? And for the Attorney General's office to say, well, he could have just driven to the police or and something. Well, that doesn't really make sense because he's still, from the driving from California to Florida, was under the control of the cartel of Victor and then of Javier. So what's he going to do? Just all of a sudden disappear? Well, then they know where his wife is. So I suggest that's not realistic. And I suggest when the court looks at the whole picture, there was evidence presented of duress. And I think that what the court has to decide here, really, where is that threshold? And as the court already pointed out, it's a very low threshold. And I suggest I don't understand why the judge would just say, here, okay, you got it. Jury takes it, they believe it, fine. They don't believe it, fine. But for the court to make the ruling, I'm not giving this to you basically because the statement he gave after the fact, he didn't mention anything about being fearful, doesn't indicate duress. The court is making its own determination as to the facts. And he did not make this determination when looking at the facts in the best light for Mr. Valenzuela. Now, if the court said, listen, I'm going to do an evaluation, I'm going to look at all the factors. And when I look at the factors in favor of Mr. Valenzuela, I really don't believe it. And the big reason why is because he said he never gave that statement after Miranda. Then I think there's an issue here, but we don't know what the judge really looked at. And I suggest for the court to make its own determination without this court knowing, did this court make this ruling, viewing the evidence in best favor for Mr. Valenzuela. I mean, that would be something the state has to prove. They haven't done it. So I suggest when you look at the whole picture, the totality, this was a question of fact the jury should have decided.
How long did it take him to get from California to Polk County?
3 days.
So 3 days. So that's really 6 days since the call, right?
Or 5 days from the call.
5 days from the call.
Right.
And no mention of a threat. No guns were used during the transport of the car or when he arrived. So a threat 5 days ago. Does that meet the definition of imminent?
Well, the threat is imminent is he's still in control of these people, of the drug dealers driving from California to Florida. It's not like he's free. They don't know where he is. He's still under their direct control because he has to call on everywhere he goes. And even if he didn't judge, they still know where his wife is. So if he disappears, they can still go to his wife if they want to.
Very good, Mr. Gregoza. That brings us to the end of the time. If you want to take 30 seconds to conclude.
Yeah, the only issue I have, and I understand how it seems to be the standard that the judge has to apply, and it's somewhat low. But I suggest that even though it's a low standard, he's met that standard, and I'm talking about the standard the court has to apply and give the instruction. I suggest that Mr. Valenzuela, when you look at the factors, has met that burden. He proved it. And I think the court also has to consider the implications that we're dealing with when you're dealing with such a large amount of narcotics, where that itself shows that this is really a serious deal going through, and these people use threats. And I think that's something that the jury should have been able to decide. This is a question of fact. when you look at all the issues in favor of Mr. Valenzuela, the jury should have been able to make this decision, not the court.
Very good, Mr. Gorgoza and Ms. Turner. Thank you very much. Mr. Gorgoza, before we leave, I think you know that I have a lot of respect for you, and we're doing these cases virtually. I do suggest next time perhaps you should be wearing a jacket.
Oh, I'm
your-
sorry. You know, Judge, I didn't realize I didn't have it on. I do have it right here on my.
I thought that might be the case, but I did want to take a moment to mention that. And,
I'm sorry. I have it right here. I just didn't realize it. I'm sitting here doing the intro to when we did, and I didn't realize. I'm sorry.
Very good. Thank you very much. And that concludes this case. The next, and you'll be escorted or removed